All right, you're fun here. It's really hard to say something nice about these two guys, and you see why, because they're here so late. Now, students, we always say to students, the networks you build here will stay with you for the rest of your careers. And Richard Haworth and I first worked together in 1970. He hasn't learned much since then, but it's, I think Walter and I started maybe 10 years after that. But it's always a pleasure. Now, these two are a little different than most of our guests because they're geophysicists, right? It's not their fault. They couldn't get real jobs. It's getting bad, isn't it? Okay? And the worst part is the gravity guys. Now, Walter went to Benny-Wein's Institute, so you will know from your marine geology course why Benny-Wein's Institute and gravity go together, right? Okay, you've all taken marine geology this semester, so you all know why that's important, why it links. Okay, and Richard did his work at Cambridge, which was very famous in the 60s as part of the whole continental drift issue. Don't believe it was invented at Lamont, it wasn't, right? Where's Gardner, so I can say that loud, right? Anyway, they're both working on the limits of the continental shelf, and I'm hoping that they can tell us the real skivvy on it. It's something that will affect all of your careers. It will affect all of your professional lives for the rest of time. And we get one shot at it. And some of your countries have already got your claims through, others are waiting. So I'm waiting with bated breath for this introduction.
Thank you. Thank you, Dave.
No better than that.
So this today's talk will be, I assume, quite different from a standard kind of science talk. It will be more about an organization, or how do you call that, a body, which was created by the UN Convention on the Law of the Sea, and that body is called the CLCS, which is the Commission on the Limits of the Continental Shelf. And the interesting part of that is that the continental shelf, as it is defined under the law of the sea, in fact has not very much to do with the continental shelf as we all know it, although it uses the same terms, but those terms actually become to have a kind of more of a legal meaning and actually are interesting in terms of entitlement and in terms of sovereign rights of coastal states that have actually continental margins and that would like to explore the resources of those continental margins. So today we were supposed to be three talking, but Martin Heinesen, who is one of our colleagues, regretfully is even more delayed. He will be only arriving at 10 o'clock or 9:30 tonight. But he will participate in some of the discussions we would like to have tomorrow with Dave and other colleagues. I'll see if I can work this. Yes. So we always, as members of the Commission, have to start with this. That is to say that any views we express in here are only the views of ourselves and do not necessarily reflect the views of the Commission on the limits of the continental shelf, or also not the views of any coastal state or our own states that have nominated us as members. And therefore we also will speak in general terms, and we will not comment on any submissions, but except in very general terms. Now, since it is recorded, we will be even more careful, but I'm sure that we can, after and during the discussions, on some of those general subjects say a little bit more, all while remaining general. So, we are new members, actually. The Commission on the Limits of the Continental Shelf exists now since about 16 years, I would say. Yeah. Is that right, huh? And the term of those of members is 5 years. So we are now in the fourth reincarnation of this commission. And in June 2012, there were elections. Those elections are actually taking place at the level of state parties. State parties are those parties that have signed or ratified the Convention on the Law of the Sea. So even though it's called the UN Convention on the Law of the Sea, in fact, not all members of the UN are member of the UN Convention on the Law of the Sea.
Like the US.
Like the US, as we always like to say. who has not as yet ratified, although we always hear that they will ratify soon, but we've heard that for the last, I don't know how long. Actually, 2012 was quite a remarkable year for the Commission, because up to now it was very often sitting members that were actually renewed and remained on, and in 2012 actually 12 members out of 21 were elected, were new members, and we are 3 of those, Martin Heinesen, Richard Haworth, who is here with me, and myself. And the system actually in the UN always works through a regional representation. It means that if you create somebody like the CLCS, we have necessarily a certain number of members from Africa, from Asia, from South America, etc. And the smallest groups are actually Eastern Europe and Western Europe and others group, who only have 3 members each. And Asia today has actually 6 members in the CLCS. So it's Western Europe and others, because that includes Western Europe, but also Canada, the US eventually if they sign on, Australia and New Zealand. So that's one geographic group in the context of the UN. And we are currently, between the 3 of us, examining 9 submissions, 9 out of the 65 that have been submitted thus far. So we're trying to juggle simultaneously, eat 3 balls in the air, and not mix up Ghana with Iceland or with Russia or something like that. So it's sometimes a very intellectual exercise. Well, I don't want to read all that, but it's clear that, you know, as already alluded to by Dave, we've been in the business of marine geophysics. And you're right, you know, I started out as a physicist actually, but I figured, well, I could get a real job in physics, but why not get an unreal job in geophysics? And it's been a good adventure, because I've been on all the world oceans, and I've been on many ships and many cruises, and it's always been, you know, you always discover things, because we know so little of the ocean floor and of the subsurface, that you know, that collective experience that we have and that we share between Richard and Martin and myself is worth it. So Richard actually was a member of the group of experts, and they actually advised the Division of Ocean Affairs and Law of the Sea, which is a division of the Office of Legal Affairs of the United Nations, who actually had to establish and assist in establishing the Commission and write the rules of procedure. Everything had to be invented that didn't exist. In the convention it said simply a body will be created, and when someone submits a request for extension of the Continental Shelf, they will meet in New York 3 months later and they will give some recommendations. Now in reality it's much more complicated, because we have so many requests, and of course there's overlapping requests, and there is conflicts, and there's all kinds of things. The function of this commission is to give recommendations with respect to the submissions, the request for extension, but also to give advice. And we in our own personal capacities have also been involved already since a long time in advising different states and different project teams and our own states teams in preparing submissions, and some of those submissions have already been have passed in front of the Commission. So even though we are new, and we are occasionally reminded by our older colleagues in the Commission that we've just come, and why would we make such comment, because we do not know anything, but we do actually know. I already explained a little bit about the geographic distribution, and here you can see the different states that are actually have nominated members of the Commission that were elected in this particular case. And even though we are nominated by a state, and even though that state has to pay our expenditures when we are in New York, we are working in a personal capacity. That's important to remember. I'm not working for France. I was nominated by France, even though I'm a Dutch citizen, but I'm working in my own personal capacity as an expert on a mission at the UN. That's our official title. So how do we work? In fact, every submission, and submissions can be quite complex. If you look, for instance, at one of the first submissions, which was made by Australia, it consisted of 1 cubic meter of paperwork, and it consisted of I don't know how many gigabytes of digital data. So it's not possible that all 21 members of the Commission go through all those materials, their maps, their digital files, the seismic profiles, anything to do with basically the description of what the continental margin, the continental shelf, and the sedimentary basins offshore state look like. So it's organized in subcommissions of 7 members. And those 7 members work together and they try and figure out whether the information that is contained in the submission is actually valid and actually proves that, and that's one of the key elements, that the land mass of a coastal state is actually extending underneath the ocean up to the end of the edge of the continental margin. So in order to make a subcommission of 7 members, we have to elect 7 members, and when we do that, we again have to think about geographic distribution. So we should have at least a member of each geographic region. So already we have 5, and then we have to look at what the expertise of the different people are. The convention actually states that we should be geophysicists, geologists, hydrographers, I think.
Yeah, we let them in.
some hydrographers. So we have to look at that. We look at what the content of the submission is. Some submissions are mainly or only based on bathymetric data, bathymetric maps. Others are based on seismic data. So you need different expertise, and so we need to take that into account. Then we need to look at conflicts of interest. You know, if France submits, and then I cannot be part of that subcommission because I cannot look at any submission by France. Or if a state has a dispute with another state, then of course the national of that state could not be involved in looking at that particular submission. The whole idea is that we avoid conflicts of interest, and those can be real or perceived conflict of interest. It's very important that we are seen as completely neutral with that respect. As I already mentioned, in the convention it's clearly stated that the state party who submitted the nomination of a member shall defray the expenses of that member. So we're not employees of the United Nations, we're not paid by the United Nations, but we are working on our own right. We do not get instructions as to what we should say with respect to any submission, including our own submissions, because as a member of the Commission we do actually have a right to be in any deliberations at the level of the Commission related to any submission, even the submissions of our own states. So, since 2012, until 2012 I should say, the Commission, which is made out of 21 members, as I said, has operated with 3 subcommissions at any single time. And so they were looking at 3 submissions at any given time. And theoretically, each member should be in 1 subcommission. It wasn't always the case. There were members that were none at any given time, and some members were in 2 or 3, just depending on expertise and other factors that could influence that. So during the first 15 years of operation, the Commission delivered 18 recommendations, and many of those were actually delivered by the last 5 years, during the last 5 years when they had a significant higher throughput, because they started already looking at 4 submissions at the same time and delivering recommendations to coastal states. So as of today, 67 submissions have been received by coastal states, and we estimate that that can easily go to over 100. Because already there are 45 preliminary information files filed to the Secretary General of the United Nations. And in those, basically coastal states say, we will reserve the right to make a real submission at a later date. And that's something which was invented later, we'll talk about that. And it's clear, so with this number of submissions, and if you say 1.5 or something like that, recommendation per year, then it will take another 50, 60 years before coastal states have recommendations. So the idea is that we have to speed up. And that concern has been expressed by coastal states for many years, but they've never actually really found any solution for speeding up the process. What they've done is they told us simply, you should work 21 weeks a year or more, instead of the 12 weeks that the Commission worked up to now. So we doubled more or less the time, and instead of reviewing only one submission per subcommission, we now review 3 simultaneously. So potentially we hope that that will speed up things. But it's not that easy, because a coastal state, of course, wants to be at the top of the queue, but once they're there, they want to get the maximum extended continental shelf. And if we don't agree to something, then they will say, but we have other data, we'll bring you next time. And we will have some other seismic which we'll shoot next year, and we will come. So the calendar is actually not driven by the members of the Commission, but once the coastal state's submission is examined, it's the coastal state that can kind of keep us in kind of a loop. So we actually had to do this third solution because we first tried to just take one additional submission, but it was impossible to actually attribute it to the existing subcommission. So we had to start juggling members, and once you juggle members, then it means that when that group meets, that the other groups couldn't meet anymore. So we decided now might as well create 3 new groups and meet in specific weeks. So things get a little bit more complicated now, because we have to now clearly differentiate which weeks we can work on which submission. If not,
I'm sorry to interrupt, but I have a question about the submissions.
yeah.
Can a coastal state submit more than one submission?
Yes.
Does that submission include all of their boundary?
They can. They have a choice to do partial submissions or one single submission. And for the 2 examples are Australia, that submitted one single submission which concerned 14 different geographic areas, and the other example is France, that submitted up to now 10 different areas, but in 6 different partial submissions.
So in the case of Australia, do you have to rule or make a decision about the entire thing as one, or can you yourself break them up and say,
Well,
this, but
it was broken up in sub-regions, and the recommendations are with respect to each of the regions. And Australia has said that they agreed with the recommendations for a number of regions, but they have also said that they reserve the right to come back and make a revised partial submission on some of the regions where they didn't agree. So, it's quite flexible in that sense. Some people think it would be better to make one single submission, but France, the reason why we decided to do partial submissions is because we knew that if we would do one single submission for all the overseas territories, we would deliver that at our deadline, which was the 13th of May 2009, and not before, and that we would be number 45 or 50 in the queue. And we thought if we do it as a partial, then we can do them earlier and get them examined faster, which actually is what happened, because we were always up to the last files. The examination took place as starting 3 months after the submission or soon thereafter. But yeah, both models are possible. So what do we want to say now? So at the moment we try to keep our groups of 7 people a little bit close together, because we have to learn to work with each other, and we want to have the maximum flexibility to deal with 3 at the same time. But at some point we will have to reshuffle and make whole new memberships and mix and match everybody in new subcommissions. And then we will meet 3 times a year for 7 weeks. We meet in January, February, or more February, March, I should say. We meet in July, August, and we meet in October, November. That's about it. We actually get the time slots that nobody wants at the UN. So, but that's how it is. And as I said already, it's important that we mix, because people have different approaches, and we have to also learn from each other and see what kind of methods we can apply. Because there's no cookbook, you know. We have to try to learn how to examine those files and based on our own experience and the experience of others. Confidentiality. This is very important. Any submission made by a coastal state is confidential, and there's different levels. I don't want to go really into details, but the subcommission has to treat those data in a confidential way. And any discussions that take place in the subcommission or between the subcommission and the coastal state, they're not shared with other members. What is shared is documentation, official letters and official documents that are presented by the state or by the subcommission. But the discussions are not recorded. They take place, yes, please?
You had mentioned that, for example, if they were reviewing France's submission, that you could sit in on that deliberation or discussion. Is there any limitation on that and how much you
No, I can only be involved in the discussions at the level of the commission.
Oh, I see. Okay.
So, but we'll come a little bit more to that a little bit later. But basically, the examination by the subcommission, there I cannot be involved if it involves a French submission. But at some point, the subcommission makes up its mind and then has to present that and basically get the commission to accept that view. And at that point, I am as a member and I can even vote at that stage. But I still do not have access to the information that was exchanged during meetings, the discussions that took place, why the subcommission decided, and if they were unanimous, for instance, on some point or not, or whether there was 6 members in favor and 1 against. Those informations I will not have because they're not part of the record. And even that record remains confidential at the level of the commission. But basically you should kind of see like 2 boxes. It's a kind of a Russian dolls inside. So each of the subcommission has its own lab. So we have an IT lab, that's where we work every day. We sit around with basically 7 members plus a GIS technician provided by WEOGs, the Division of Ocean Affairs, and a legal advisor who helps us, you know, in anything we need. And so when we're not in the lab, then we have a secure email system where we can transfer large files and we can actually discuss and see what you know, things that are happening within the subcommission. But those are not accessible to people that are outside that subcommission. So each of the chat rooms and the file folders is dedicated to members of a particular subcommission only. But it means that the members of those subcommissions, they can actually continue their work, and we do continue to work while we're back home as well. So this is a very important point. When a state makes a submission, generally at the next session of the commission in plenary, so when 21 members meet, that state will actually come and present the general overview. And after that, when it's time for examination, there will be a subcommission established, and one of the first questions will be, what is the level of confidentiality of your data? Can we actually take your data with us on a secure computer, and can we work on it at home, or can we only look at the data in the dedicated room with an officer of the UN present? Basically, that's the question. And there are states that say no, you cannot take anything. Other states say yes, you can take the written information, which is more like a manuscript kind of main body of text, and other states say you can take the whole GIS, you can take all the data with you, as long as you don't share it with anybody else and you keep it secure on your computer. In which case, we can make progress because we can work at home, and that makes. So it depends, but that's up to the coastal state. They will have to tell us what level of confidentiality they will have, and depending on that, we explain to them that we can work fast or not as fast. So it's in their interest, but sometimes they just don't want to make any data available outside of the UN premises. All the information is in any case available, so all the official parts can be seen by any member of the Commission at any time. And each member has as I said already, has the right to participate in the proceeding of the Commission in respect to every submission, even including those of their own coastal state. So what did we want to say here? Yeah, I already said in the beginning, there's 12 new members, and there's only 4 members that have been there since the first Commission. So therefore, in order for us to ensure some kind of a continuity and some kind of a coherence between different recommendations, it's extremely important that we actually have access to that kind of information and to all the recommendations and to previous submissions, and that regularly we go back and look at examples of how was this dealt with in this particular case. And we all have in mind, if we look at the continental margin of Ghana, then I'm immediately looking at the one of French Guiana, which is more or less the conjugate, so that I have I can see that somehow there is a coherent approach, and that the results are past scrutiny, basically, of a certain continuity. But on the other hand, it also remains clear that any submission and any examination of a submission is between a coastal state and the subcommission in the first place, and then the Commission, because states do not provide the same data, not the same quality of data, not the same quantity of data, they don't have the same approach. So you cannot guarantee that you get exactly the same recommendations for things that may look similar, because the content of the submission is different, which is a variable that you just have to live with. In terms of what actually comes out of what the Commission does, the Commission actually publishes on the website of the UN the executive summaries of the recommendations, as well as that at the moment that the states submit a submission, the executive summary of the submission is also published and available to everyone.
Is it possible, would it be unethical to use data submitted for one submission in adjudicating a different submission?
By that depends. By whom you mean? For us?
Yeah.
As members of the Commission?
Yeah. Would that be considered acceptable?
We as Commission members, we look at data that have been provided by a coastal state. If we know of the existence of other data, and if we think that could be pertinent, then what we do is we tell the coastal state, have you looked into such and such data that exist at Lamont, or that exist or collected by, or that are available in the public domain? That we do. But we will not make recommendations based on data that's not contained in a submission. But we may keep in mind that based on similar data somewhere else, such and such recommendations were made, and therefore if we want to make different recommendations, we have to make sure that we can justify why we reach a different conclusion.
So this may be a naive question, but why not require all submissions to be in the public domain, totally in the public domain?
Well, the problem with that is that many states use, for instance, oil company data as for one of the questions, which is the sediment thickness, which is one of the criteria of extension, which is a so-called Gardner formula, or 1% sediment thickness. And so most of the time, those data, they may have access to them, but often they can either not even provide them to us, or they can only provide images, and very often they want those data to be completely confidential. But yeah, I mean, in an ideal world, I've always felt, and I've always argued in the organizations where I worked that we better make data available and have people use them, rather than trying to keep them proprietary and try to sell them. And there's a typical example. I was not only doing gravity, I also was in aeromag. And at the time in Australia, the aeromagnetic data collected by the government were very expensive, and nobody bought them. People said, we're not going to buy that stuff. It was really extremely expensive. And at the time when they changed the geological survey, or which is called the BMR, I think.
Yeah, Bureau of Mineral Resources.
Bureau of Mineral Resources became AXO, Australian Geophysical Survey Organization. They changed policy. They said, we're going to put everything in the public domain, and we want people to use it and start exploring and do something with it. And all of a sudden, everybody wanted the data. And actually, it had an impact. So it's true, data sitting somewhere not used is not very useful. But that's maybe a dream. This is actually a valid point here. Executive summaries, the first executive summary we did as France, we put more information. Finally, we looked at the practice of others, and we decided the executive summary should contain the minimum of information possible, because people can work back from what you present to see what you maybe have and what you maybe did and so on. But is that a good idea? I don't know. That's the reality. And similarly, some executive summaries of recommendations have more information, and clearly can, people who read them actually will understand what drove the Commission and why they made certain recommendations. Others are relatively vague. So that's something I think the Commission wants to work on, and try to work on a model where our recommendations, and at least the executive summary that's public, are more readable and are more clear, and so that other states can also benefit from that. Yes.
Are submitting states free to publish the Commission's full recommendations?
Yeah. New Zealand has done that, and I'm not sure if others.
Ireland
also did, yeah. They are.
Walter, can I deduce from this that the phrase there is ensuring continuity of corporate knowledge is getting close to making this into common law? There's nothing inherent in the treaty that says that any decision made on submission number one has to pertain to the Commission, right? It's not, okay.
No, it's not, and it remains, as I said, there's so many variables, but we're nevertheless, if you want to be fair, I think we need to aim at some kind of a coherent approach. But yeah, it will always remain a case between a coastal state and the Commission, because the content, even though, and Richard will talk about the scientific and technical guidelines, there is some kind of a quote-unquote cookbook for how to make a submission, but they're extremely variable, and there are extremely rich submissions with a lot of data. There are submissions that have a lot less data. There's countries that spend hundreds of millions, and there's countries that spend hundreds of thousands to make a submission. So it's so we have arrived to this point here. That means that now Richard will actually take over, and he will take the second part of this presentation. So the light's in the middle, and the thing is just okay.
As Walter says, this is the key to where we change. We had to change all of this when, unfortunately, Martin could not join us. But I think the fact that he isn't here is indicative of how seriously we take this job. Everything was going fine until lunchtime yesterday. I think it was.
No, even later.
Was it
2 o'clock.
2 o'clock? And suddenly Martin said, I can't come. And the problem is that I have to be part of a discussion about a submission that's taking place today, Friday. And he felt that he could not be here. We were able to get away with a little bit of fortune, I would say, but in this particular case, he felt that he could not be here. So let's go on to the next one. As Walter said, scientific and technical guidelines were published in 1999. As he mentioned earlier on, I got involved in what was called a group of experts in 1993, which was when the UN suddenly realized that the law of the sea might be ratified in the next few years, because it comes into force when 60 states have ratified the convention. And so that eventually happened in 1997, which is when the commission was established. And what happened in 1997 was that they took the commission, the members of the commission, the 21 members of the commission at that time, took the draft that we had, that a group of us had prepared which started in 1993, we continued in 1995, and they took the, I don't know, 20 pages or so of draft guidelines that we had, and they went to work on them. And it took them 2 years to produce the full technical guidelines of the Commission. And they were published and they were accepted by states parties in 1999. And as Walter said, they're just that. They are guidelines. But they express to new and old members and to the outside world the understanding of the Commission of the relevant paragraphs of UNCLOS. Now the problem is that UNCLOS is very vague. I remember going to a meeting in Jamaica at which I was supposed to explain the technical background of the law of the sea to a group of lawyers. And I thought this was a good opportunity to get my own back on the lawyers, because the lawyers had created the convention, and the convention was very, very vague. And I berated them about it, about the fact that it was so very, very vague. And they said, no, that is the success of the convention. Because if it hadn't been vague, it wouldn't have been passed. We wouldn't have had a convention. And I thought, well, that's probably very true, but now it's left to us. We have to interpret these in terms of these guidelines in order to try and interpret what was originally intended as part of the convention. So that's really what we have. We have those guidelines, and they've been applied, and they've been reapplied, and they've been reinterpreted. And a lot of people have said, why don't you revise the guidelines to bring up to date all of the thoughts about how the Commission should accept information, how it should treat information, how it should interpret information. And I am very much against that, I must admit, because it took 2 years to produce them, and the application of them is evolving. It evolves every year. It evolves with every submission that we look. And whoops, what did I do? What did I do? What did I do? What did I do? There we go. All right. So the practice of the Commission has evolved through the application of these guidelines, and I think it's that we have to look at. We have to look at how the guidelines have been applied, and so far as we're concerned, you have to look at the recommendations that come out of the Commission in order to understand how the Commission has applied the guidelines. With respect to the previous slide, there was a question about precedent, essentially. And I've been involved in looking at one particular submission where we were being hammered by the state as to whether one of the principles that we were espousing was actually demonstrated by the previous practice of the Commission. And it was a back and forth discussion. And the problem that we had in this particular case was that we knew we were right because we had access to the full recommendations rather than the summary of recommendations. This is the kind of problem we get into. The summaries are just that. They're not the complete recommendations. And in many cases, you can only find out what the subcommission really thought was the guiding principles of that subcommission by going to the full recommendations. And that's why we have to have access to them, so that we can understand how previous commissions have looked at these things. So we try to understand how the evolution has occurred by seeing how they've been applied, and the best way of doing that is looking at the comparison between the guidelines and the recommendations that come out. The other place where you can find something, after each session, there is the statement of the chair of the commission, and that is prepared. It's prepared jointly within the commission as a whole, but it is ultimately the statement of the chair, and in those particular statements you can again glean more information as to how a particular submission is going through the commission, how it's being dealt with by a subcommission. There is a lot of useful information in there. The problem is that there could be a lot more useful information in there, and I had somewhat of an argument with the Secretariat about this last time, because I kept on trying to put more information into the statement of the chair, and it was deemed too long, and therefore you cut out stuff. And I said, well, if you're not prepared to put anything in, I can put even less in. And unfortunately, we have a little bit of a problem about that at present. But the statements of the chair, as well as the recommendations, can tell you a lot about what has happened to the treatment of a submission. So what other sources of information have you? Well, presentations and publications made by members of the Commission. We always have to create a disclaimer, but there are many people like yourselves who listen to people like us and say, oh, he said that, now that's telling us a bit. And so any presentation that is made usually provides some useful information. For me, this particular paper is a very, very useful one, because the question about submarine ridges and submarine elevations is somewhat of a complicated one, but there have been many published summaries of recommendations which relate to those, and Harold Brecker and Phil Simmons have been involved in many of those discussions within subcommissions and within the Commission, and they have published this particular article which quotes from many of the recommendations from submissions. I think I'm not telling tales out of school, because this actually is in the chairman's comments. Walter was involved in one particular submission and was having trouble. He was on behalf of France. He was talking to a subcommission about where you would find the foot of the slope, and it was clear from what was in the statement of the chair that France was having trouble with this particular subcommission. And I will paraphrase what it said in the chairman's comments, because it says, for God's sake, if you will, you tell us what you want. It doesn't quite say that, but that was clearly the import of what was actually reported in the statement of the chair. And as a consequence, the commission or the subcommission produced a definition of what information they required as part of the foot of the slope, so that France could go forward in that particular case. So we have this as an example of what you might look at in order to give you some indication as to what's the submarine ridge, what's the submarine elevation. Now, so that to some extent has been dealt with, but we know that these three things are being examined at this moment. We've got questions as to whether evidence to the contrary should be used. It's quoted in Article 76 4b, but it says if you can't find a foot of the slope, essentially on geomorphological grounds, can you find any evidence to the contrary that would show you where the foot of the slope is? There is a question about sediment continuity. You have to look at sediment continuity in order to tell you whether a particular sediment thickness is appropriate, and what the continuity is between A and B. Well, what is A and what is B in this particular case? And then we have how far can you extend the limits of a continental shelf for a nation that is, or for an entity that exists on a ridge. And if you look at the executive summaries of submissions by Japan, Iceland, and the revised partial submission by South Africa and France, you will see the differences in interpretation, or the differences in application of the guidelines in those particular cases. And it's very interesting to look at those. And if you want to look at anything, particular, you can look at the summaries of recommendations regarding the submission by Japan, and that by the UK with respect to Ascension Island. There's a lot of very rich reading in looking at the summaries of recommendations of those with respect to what can happen along the ridge. When part of the essentially the rules that were set was that a coastal state had to submit scientific and technical data within 10 years of the convention having come into force for them. So, for example, in Canada, we did not ratify. Dave and I spent a lot of time, many years, trying to convince Canada to ratify the convention as early as it could. In fact, we didn't ratify until 2003. As a consequence, the clock started for us in 2003, and so we in Canada will be submitting by the end of this year. So you have 10 years. So for some of the states who had ratified in 1997, they had 10 years to do it. But the problem was that the guidelines weren't published until 1999. So states parties to the convention agreed that the 10-year clock should start on the 13th of May 1999. But the problem was that by 2009, which is the 10th anniversary, many of the countries who had ratified early on still had problems in producing and collecting and in interpreting the information that they needed to make a submission within that 10-year period. So in June 2008, just before this deadline, they said that, all right, we will let you off the 2009 deadline, but we want to have from you some preliminary information which indicated three things. What are the outer limits of the continental shelf beyond 200 miles that you expect to have in your full submission? How far along are you? What's the status of your preparation? Are you still collecting data? Are you interpreting it? Are you waiting for something that will come and help you? And what's the intended date of making a submission? So those were the restrictions on states parties at that particular time. So far, it looks as though we're going to have states who have said, yes, we're intending to make a submission by a particular time, and they may not make it. We also have some who have been very vague in the intended date of making a submission. Maybe we're hoping to do it in the next 15 years, or something like that. Very, very vague indeed. And if you look at some of these preliminary information, I wouldn't say that it's preliminary information, I would say it's very, very vague information about the entire operation. In some cases where we've had that, the state has suddenly come up with a good submission in a very short time. So even from the preliminary information, you can't really tell what's eventually going to come out. But that is what is there. But there is a little bit of a problem with this, and we haven't solved this yet. We haven't had a situation yet where this has become a problem. If you have two states and one has made a full submission, it's collected all of its information, it's done all of its work by the 10-year period, and it has a maritime boundary with a second state which has only submitted preliminary information. So one's a full submission, one's preliminary information. And state one may be ready to undertake development if it's offshore. It's got a submission, it wants to know where its limits are, and it wants the information quickly. But state two is still to make a submission, and it will wait, and it can wait, and it can wait. So the problem here that we see is that state one is never going to get a complete answer to its maritime boundary with respect to its neighbouring state, because its neighbouring state isn't doing anything. So the problem is, how do you break this particular stalemate, if there is a stalemate? And if there are 67 submissions already in the queue, how many years of delay is it which is being caused by the impact of state two on state one? And I wonder whether at some stage this will become a critical question that states parties have to address. We are, as we constantly are reminded by one of our colleagues, we're not the only fish in the sea, so to speak. We have the International Tribunal for Law of the Sea, which is essentially based in Germany, but it's one of the bodies established by UNCLOS. It's a legal body populated by lawyers, and they get involved where, as an international tribunal, where there are points of law that have to be arranged in the settlement of disputes that arise between states. And this recent ruling, which is Bangladesh and Myanmar, they were called in to essentially settle the dispute, and they did settle that dispute. The problem was that ICLOS produced a ruling which extended beyond 200 miles, and in that particular area there are no commission recommendations exist. So there is a conflict here between what ICLOS is doing as a legal body and what we're doing as a commission, looking at recommendations beyond 200 miles. So that's the first time where that kind of conflict has potentially existed, and people are mixed minds as to how much of a conflict that is. The other body is the International Seabed Authority, and they are charged with the management of the area. And the area is the area beyond the limits of the continental shelves of states. So essentially, the more that we, in our recommendations, approve the extent of a continental shelf of a coastal state, we're beginning to infringe on the area. And the area is important because it's the area, the resources of which are to go essentially to the UN to be divided up. We still have to figure out how, between the non-coastal states, who've ratified the convention. Because it's not only coastal states that have ratified the convention. Switzerland, for example, is one of the adherents, and Switzerland hardly has very much of a coast. It has inland coasts, but that's all. So the area, the resources of the area, are to go to landlocked countries. And now, what's happened? It's happened only in the last couple of years. The International Seabed Authority has suddenly been faced with a significant increase in minerals in the area, primarily in the Pacific, but it's extended into the Atlantic now. So these are the resources, for example, on the ridges, on the fracture zones, where known mineral deposits exist. There's been a significant interest in that. So although no potential mineral development has been proposed within or close to the limits of a continental shelf, that's beginning to become a problem. The interface between the continental shelf and the area is beginning to be a bit of a challenge, and so there has to be some interaction between the Commission and the Seabed Authority. And in fact, we have one current member of the Commission and one former member of the Commission are also members of the Legal and Technical Commission of the International Seabed Authority, and they're the people who do all the technical work, essentially, with respect to resources in the area. So those are the other bodies that we deal with, but we certainly deal more with the Seabed Authority than we do with the lawyers. The Division of Ocean Affairs and Law of the Sea, they're essentially the host organisation under with whose help we operate in New York. So we depend upon the support, as Walter mentioned. They provide the IT support, they provide legal support, and it has been a long-standing organisation. We've recently got they have recently got a new director. But like all portions of the UN, they've got a reduced budget, and they're facing more demands for their services, and we demand more from them, and they say, well, we can't do that because we're having to reduce the budget. They've actually done a very good job in actually protecting the resource and the services that we get from them, even at the expense of having a larger manpower within the office. So as an example, the computer labs and the storage facilities that we have in our DOLAS labs are paid for out of their budget. One of the problems that causes us a problem is that they are trying to minimize the costs of online storage. I can't remember the cost, but it's a significant cost that they have. So they're very reluctant to keep past submissions and recommendations online for us, which causes us problems because we need access to those in order to try and define how we actually deal with current recommendations. So there's always a battle between us and DOLAS as to how much shall be online and for how long it shall be online in order to enable us to do our job. Recently I was looking at a submission and I needed access to Australia's submission. And as Walter said, when you're faced with a cubic metre of paper or however many terabytes there are of information, they're very reluctant to put that up and leave it up. They can put it up for a while and you can use it, but then they try and take it offline again. So the problem is that all the data that have been submitted are not available online at any time. And we can only access that data online anytime when we're in New York, unless we manage to get permission to download it and take it home with us so that we can work on it at home. So each time a member wishes to see data that's previously been submitted, extra costs are involved. So we have this continual fight with DOLAS as to what we should do. Walter and I were talking on the way down here. In the main conference room, we use that conference room to talk to states about their submissions. But in fact, the computer that we have in the conference room is not nearly as powerful as the ones that we have in the lab, and therefore we can't do a full analysis in concert with the state as we would like to do. And that causes a great deal of tension within us. Areas of interest, I put this in because it's a personal thing, because we are going to be making our submission by the end of 2013. And most Canadians will read in their newspaper that we're at war. This is war. This is the Arctic, and this is Canadian Arctic, and other people are trampling on our ground. And what are these Russians doing by planting flags? Things like this. We are busily working in the Arctic. Denmark is going to make its submission very shortly. The Russian Federation, the Deputy Minister has said that they will be submitting in 2014 or perhaps early 2015. Norway has already submitted. It's received its recommendations and agreed on a lateral boundary with Russia. The US is the only nation whose continental shelf has a lateral boundary in the Arctic, has not yet ratified UNCLOS. And I keep telling all of my colleagues in Canada and all of my friends who read the newspapers and wonder how aggressive is the relationship between these countries. And the four of us know that it's the five of us, know that if we didn't work together, we would not be able to make a coherent story or submission in the Arctic. and therefore we work together, and there's no animosity. There is great collaboration that happens. One of the things in the I don't think this is a secret, in the Commission we sit in alphabetical order. So we sit around 21 people in alphabetical order, and the colleague on my left is Mr. Glumov from the Russian Federation, and we spend most of our time when we're in plenary and not doing anything talking about the Arctic and working together on solving each other's problems about the Arctic. So far as we're concerned, the scientists, the way that the relations are overblown in the press is totally opposite to the way in which things are happening, and because of all of this, there will be a great deal of negotiation of lateral and potentially opposing boundaries in the Arctic. That we have nothing to do with. We can explain what the area of a continental shelf any state will have, but if that overlaps that from another state, it is the two states that have to settle their lateral or potentially opposing boundaries in the Arctic. So I think in terms of the Arctic, and a lot will be happening in the next little while because of what's happening here, I think you can expect less rancor regarding the submissions than appears to be the case in Southeast Asia, where on a regular basis one is reading in the press about the kinds of territorial ambitions that there are between states, and essentially those states having overlapping, potentially overlapping continental shelves. So in the case of disputes, we're not lawyers. We don't claim to have any legal experience or qualifications, and so we are excused from making any decisions about the delineation between states with potentially overlapping continental shelves. That's the business of the states themselves. And so in the recommendations always say that these recommendations are without prejudice to the relationship between those coastal states themselves. And in many cases we've had a lot of discussion before our joining the Commission. We've had lots of discussion with members of the Commission about why there are so many objections. If all the recommendations are without prejudice, then why are there so many objections by states to saying you should not look at so-and-so's submission? The recommendations that we've always had is that if you've got a neighbour with whom you have a potential overlap, then settle those disputes as early as possible, because if they come to the Commission and a state objects to our looking at a particular submission, then in generally, if there is a specific dispute between those states, then we're powerless. We essentially we are not allowed to look at those particular submissions. So the best thing to do is to get things sorted out before those submissions come to the Commission. So we've tried to give you a little bit of a background. We can go into this in greater detail if you want, and we shall no doubt be talking about this with Larry and David tomorrow. It's been my hope, my prayer to be a member of this Commission since I got involved with the group of experts back in 1993, and it was only after 2003 that we were able to actually make a nomination of a member. So far as I'm concerned, this is a great opportunity, and one of the things that it sounds, we're pleased and proud to be members of the CLCS. It really is exciting work. It's very engaging. That's why Martin isn't here. He got so engaged in the submission that he said, I can't go tomorrow. I've got to stay and sort this out. And that's what it does to you. It really is engaging work, and it is exciting, and it's scientifically challenging. one of the things that we have tried to do, because we're three, so if there are 3 subcommissions, we can't be members of the same subcommission. But we always keep in touch with each other, and we do 2 things. Every morning I make the coffee and Walter drinks the coffee and we settle down in either his lab or our lab and talk about what we've been doing. So we keep in touch with each other about how things are going. And Martin gets in later. Don't tell him I said that. But we always make a point of meeting for beer at 5 o'clock on Sunday evenings to keep track of each other and to know how our subcommissions are working and the kinds of challenges that we have. But it is exciting and engaging work. And we have to make those, we have to do that so that we can keep abreast of what's happening. So that's a personal thing. The great thing for people outside, I hope, is that more submissions will be examined more quickly because of the changes in the way we work. July and August is not the best time to be in New York City. When my wife was asked whether she was going to join me for any part of that particular session, she said, "You must be crazy." So she goes off to the cottage while I sweat in New York City. But we do it, and it's great. Walter said the only reason that we're there in sometimes is because nobody else wants to be there. We have a problem at present because we whenever the commission meets as a whole, 21 members, we have to have simultaneous translation into the 6 UN languages. It's one of the stipulations. And at present the General Assembly is meeting, so all the translation services are tied up. So we can't meet as 21 members to discuss matters of interest during this particular period. So the modus operandi we work around. There are many challenges on the horizon, but we can change some things. We've started, and in many ways it's because of WEOGs stirring the pot that we've got some of the changes that have happened so far. And there are other changes that might improve the through flow and availability of information to non-members. So we've improved the through flow. Now it's a case of how we can actually provide more information to you people and to everybody else so that you can understand how the Commission is operating and some of the rules under which it is operating. So there we are, the 3 musketeers. And as I said, it's the WEOGs, the Western European and other groups. The WEOGs are united, or is that the WEOGs untied? So there we are, and you may get to see, oops, I've done it again. You may get to see Martin tomorrow. So that's it. Thank you. I know we've gone over time, you started late and but if you've got any questions, I'm sure that Walter and I would be pleased to try and answer anything. If you want to go. Don't know what time beer starts, but any questions?
I have one question. It kind of gets back to the comment that was raised earlier about full disclosure of the recommendations and how only the 21 commissioners have access to that information. And then what's published so that other people in other countries can access it is very limited, and sometimes it's not even robust enough to prove why you made those decisions. I guess it comes down to what's the thought process behind that? How is that going to help other countries with their submissions? How is that going to help a neighboring state that may have a potential conflict with that particular state regarding another issue? How does that translate into practice?
Well, you have to recognise that that many states are not altruistic. They're not going to help somebody else. That's just one of those things. The state has the right to restrict what we put in the recommendations. They have that particular right. We can perhaps object, or we can perhaps suggest that the rationale for their restricting information is incorrect, and that's happened actually. That has happened, and states have eventually released more than they were initially prepared to release. So it's up to us, or WEOGs as a whole, to try and persuade countries to allow more recommendations to be published. one of the problems that we face is that, well, I had a discussion the other day, and it's becoming more widespread that the Commission will recommend the full disclosure of all the important information that is in the recommendations. That has become a trend. To start with, we had lots of recommendations, and the summaries were, say, half the information. But in recent years, there's been more of a push to publish all of the, and I say important information, because there's a lot of introductory stuff, which is why Walter was appointed to a particular subcommission on a particular date, and that's of no importance. Well, it is actually, but it's usually of not great relevance. But the bulk of it, we're trying to make sure that most of it is published, and that's about as far as we can go. The other side of the story is that there is, from the perspective of some members of the Commission, the more you tell about what went into the recommendations, the more that you can get hung on looking at another submission later on and say, oh, you didn't follow the same kind of precepts. So there is, on some members, the wish to say as little as possible about the where and the why, but to come out with the result. This is the end result. The problem there is that you, in reading that end result, may not know what went in, because the executive summary has so little information in it. So we're aware of that. We've spent so much time on the other side of the fence that we know how important that information is. So I hope you can rely on us to try and get as much more information out as we can.
No, I agree totally.
I was going to ask a similar question. There's situations where you talked about the need for states to resolve their issues ahead of time, but it seems to me there may be opposing or adjacent situations where the ultimate limits of the shelf have a lot to do with how the states might resolve some of those. So it seems like there may be a chicken and egg or horse and cart kind of problem there sometimes.
I can give. Let me give you one example, which I think is a. I think I'm not talking off the record here. We know how that India and Pakistan do not exactly work well together, and they have a dispute at the coast. But there is no reason why that issue at the coast should be of any particular relevance when you're out 200 miles, because we're looking at boundaries that are beyond 200 miles. And in many ways, I've been talking with those states to say, why don't you come to some agreement about what happens beyond 200 miles, because it's not going to be affected by what's happening inshore. So, but in that particular case, politics is king. And so there will be no agreement until there's been an agreement inshore. And we can't do anything about that. We cannot do anything about that, because that's the nature of the discussion between the states. You got any other?
Well, there's another example is the Jaeger Basin. And again, that's not confidential, because that's all in the public domain. But there's three states actually claiming an extended continental shelf in the Jaeger Basin. It's Norway, Iceland, and Denmark for the Faroe Islands. And Norway actually comes from two sides, because they have a Jan Mayen Island and the mainland. So there's basically 4 entitlements in this area, and the 4 states, they basically said, well, the area will be about this size, and we will give everybody this percentage, which boils down more or less to 50% to Norway, because they have 2, and 25 to each the others. But if the Commission gives less, for instance, to Denmark than what that 25% would represent, then they've already said, amongst ourselves, they have signed, it's public, you can read it on the web. Then what remains will be divided along the same principle between the other 2. And if the other 2, one cannot, then the last one will have everything that the others couldn't have, if the Commission recommends that they could. So they have basically divided the pie, which is hypothetical for the moment being. The third example, and then I'll stop, is between Australia and New Caledonia, France, in 1982. So even before UNCLOS existed, they signed a limit on the Lord Howe Rise, which is the delimitation between France and Australia, completely in international waters, beyond 200 nautical miles. And it was basically stipulated, if ever this becomes an extended continental shelf, then this will be the limit.
Okay. We're going quite a bit, we started late, so we're making up for it, like, ending late. Very generally, we all say about 10% of the seafloor has been measured acoustically, and what it really means is available to us. And there's been quite a lot of data, bathymetry data collected for law of the sea claims. And it's ironic that largely it's only the United States, which is not ratified, that's made that data available to the world. Right? Now, I think that we as professionals in this field have a responsibility to try and get all that data into the public domain. And obviously, I'd like to see it in Jebco and everybody else to use it. So, is there anything that you guys can do from inside to sort of stoke fires?
Yes, we can. Whether we succeed or not is another thing. There's two sides to this, because there is one example where one country spent a lot of money to do a lot of surveying in a particular area, and an adjacent state used public domain data and essentially came to the same conclusion. So the public domain data is used by some state, and you can certainly, the members of the commission are well aware and do their homework about what is available in the public domain to bring that to the attention of states, and you can use that to encourage them to put that other data into the public domain. It's a hard sell, Dave.
Yeah.
It's a hard sell, but we know how valuable it is, and it's only by talking to states and saying, look, you've used this stuff. Get out and act as a salesman to get other stuff into the public domain. But it can be a hard sell. A lot of it is confidentiality, because a lot of the things that we deal with, we know are not going to go into the public domain because they are confidential. But for example, there is a lot of multi-beam data that exists within state submissions, for which there's no reason why it should not go into the public domain. And if we could do that, that would help a great deal.
Okay. I think it's been long. I'm looking forward to having at least one beer with you guys.
Only one?
But thanks very much for